All right, so we are continuing from where we left off with a state law. Right now we're dealing with allodial title and the Constitution. And once again, you never know what position you be in. We might be in a better position, more centralized, organized, things like that. And these are laws you want to just have in your arsenal, just to know in second nature. All right. So allodial title and the Constitution. All right. Allodial title constitutes ownership of estate, land, building, and fixtures that is independent of any superior landlord. Allodial title is related to the concept of land held in allodium. So these are the law terms that if nobody is familiar with, just look it up in law, the law definition of allodium, Black's Law Dictionary, 4th edition, or older. Allodium, or land ownership by occupancy and defense of the land. That's the key part. That's why I say, Moors united on the same level. This concept is rooted in your right to life, liberty, and pursuit of happiness. Compare this to the feudal fee homage system to a monarchy. In the feudal system, you owe the crown. In the allodial common law, Republican, communist, socialist, constitutional system, you only owe what it costs to maintain your property. Here's a little schematic, of course, the land and everything upward, right? Estate tax doesn't apply to your home if you hold it in allodium. Meaning, every man, woman, child in the house is armed to the teeth and will not allow anyone or anything to come into that home estate to do or take anything without their permission. All mortgages, foreclosures are based on feudal law. Chattel property, meaning they feed off you like a cow, and they only allow you to graze the grass, meaning you pay them to live when you don't have to. And since you're repaying them, they are feeding off you. Literally. But since you pay them, they don't have to work. All they have to do is ensure everyone is paying their mortgage and not fighting back. Your job is to remain docile and think without being able to graze on this patch of grass, or I'll starve. In reality, all you and the other cows have to do is break down that small wood fence and graze on whatever you want. This in law is called adverse possession. So this is a law term called adverse possession, and is related to allodial title in regard to the fact you have to be willing to defend your home from adverse claims and invasion. So I want to just cross-reference this with a definition of adverse possession, so you can see the term, that it is a law term, right? So you can just I'll just put elements of adverse possession in any search engine, Google, Wikipedia, Bing, Yahoo, whatever. So what is adverse possession in real estate? So as you can see, this is a term. Adverse possession is real estate lingo. So here are the key points. Adverse possession is a legal doctrine that allows a trespasser to claim title and ownership right of a piece of real estate after a period of time. In our case, we're not trespassers. But in this context, they're still saying you can own it if certain requirements. Now, requirements of adverse possession include exclusive use, continuous use, and open takeover of the land. So this is just a generic. I just looked this up, right? On Wikipedia, Google, and they're telling you one of the elements of adverse possession is continuous use and open takeover. You just right. It's apparent, and in our case, as more, we got principles on why we're making an adverse possession because our claim is the highest because we're the heirs to the land, right? So the rights of indigenous people, right? We got the treaty, right? We got trust law, all right, and you have to physically see some Moors on the land. Okay, it was rough. You might see them mowing the lawn, getting the weeds out, changing the roof, painting. Once it's apparent that the Moors came and then it looked rough at first, and now it's looking good. That's a signifier that we're on the right page, right? All right, so I just wanted to show y'all that adverse possession is an actual law term, right? All right, so nationalize, transfer, a major branch of industry or commerce from private to state ownership or control, make distinctively national, give a national character to the property, right? So an example would be what happened in Cuba, where they nationalized all the sugar cane, all the business infrastructures that the United States had in Cuba. They basically said Cuba for Cubans, and all the Cubans was like, nah, any foreigners that's over here, we nationalize, we don't care. The United States took the Cuban nationals to court and lost based on these principles. Because what happened was the law kicked in, and then the people had backbone and knew the law, right? And they just they were themselves, you know. That's why it's important that opposition make us forget that we got inheritance ties to the land with the whole black, Negro, color, Latino, Hispanic thing, because you won't even think to use these principles once we start uniting. All right, and the state is everything comprising a net worth of an individual, including all land, real estate, possessions, financial securities, cash, and other assets that the individual owns or has a controlling interest in. This connection, part and parcel, that's another land, that's real estate talk, part and parcel. This connection, part and parcel, is why when you sign a mortgage pursuant to feudal law, you pledge your life to the crown, as your estate is everything you own, acquire, and do. So here's an example of an affidavit that you would file on the record, county clerk, and most times you want it to be in the body of a trust organization of people where property is being conveyed to the temple or to the organization, not just one person. That's another signifier of national principles, that the property is for the benefit of the whole and the heirs, right? So it got to be some type of honor. So mortgage writ of discovery. So of course, I'm not gonna say of course, because some people may not know what discovery is. It's pretty much the right to know information, right? So in this case, this would be an example of a writ, which means command on paper, in affidavit form, stating principles, right? So if we was to Joe Blow, we go to the county clerk and we look up their records and be like, who owns this property? We look, we find that person that quote unquote owns it, right? Once we find out all that information, then we will find out who either directly or that corporation, and then who the CEO of the corporation. Typically, it's a bank saying they own something or whatever the case may be, right? Then you will hit them with one of these mortgage writ of discovery, right? So two, insert the name of the bank, right, or the mortgage company that's claiming they own it. Insert the free national name, but like I say, most times you want it to be an organization. You don't want it to be one person, and then enter the straw. But of course, this is just an example, just all right. So in Ray means in response. So typically when you file something on the county clerk of this nature, you're gonna get some type of something in the mail saying, "Oh, whatever, we're gonna take you to court, whatever the case may be, just to settle this out." All right. So in response, answer here, right? Trust name. In response, enter the trust name, estate, care of, mailing address, the latitude and longitude, not the street. So whatever, like out here, big streets like Western, Rodeo Drive, whatever the case may be, that's not how you identify property. You go by latitude and longitude of the earth. That's how you lock down a square, what you're saying, we're trying to adverse possess this. Latitude and longitude, right? The parcel ID number, and you'll find this in the county clerk records, and the alleged loan number that the quote unquote bank said whatever they gave you, and the FHA number. And this is just so the pseudo people can locate what you're talking about as well. Affidavit of fact and discovery, writ of right. That's another writ of right. They kind of go hand in hand. And this is addressed, right? Dear Dear Bank, Dear Bank of America, Dear Chase, Dear Property Management, whatever the case may be. In order to come, and once again, it's an example, in order to come to a peaceful resolution in regards to any alleged foreclosure, eviction notices, or payment owed, I am exercising my constitutional and contractual rights to discovery on this matter. It must be fully disclosed that I, free national name, am an Aboriginal and Indigenous Moorish American distinguished from, and not to be held as surety for whatever, if you came in with the straw. I am the natural person who currently inhabits and is occupying the living quarters corporately, referred to as care of whatever the corporate address is, land parcel ID, insert the parcel number, and the most importantly, geographical location, insert longitude and latitude. Once again, I have received mailing communications from your agency regarding the alleged loan number. Please mail to me the following certified and verified official copies of a loan, related documents, and answer to the following questions so that I may make a physical inspection of said documents and answers to verify whether or not you or your agency has a valid claim or interest to my ancestral estate. 1, these are questions. Because now we're getting in law. That's why everything is in the affidavit form. Because now it's point for point. Produce the original promissory note, front and back, associated with the loan from your agency, entity, persons to the borrower. 2, produce any allonge, bill of exchange, and or promissory note, front and back, complete with any affixtions or allocations attached to the borrower promissory note for endorsements. Produce all bookkeeping journal entries associated with the loan to the borrower. Produce the deed of trust associated with the loan to the borrower. Clearly identify who the creditor or the grantor is and the debtor, the grantee. Right? These are elements that need to be ironed out. Who's the grantor? Who's the debtor? Produce the account number from which the amount came to fund the check given to the borrower. Right? Produce the verification that the borrower's promissory note was a gift or donus to the lender from the borrower. Produce the name and address of the current holder of the borrower's promissory note. Produce the name and address of the lender's CPA and auditor for the period covering the execution. Produce a copy of their legal authority and bond number to do business in the state of California. I mean, wherever you at, wherever corporate state you at. Produce the bill of particulars and or receipt that proves that the loan, quote unquote, was in fact lawful money, i.e. gold or silver coin or anything of value. And that's back to contract law. It's called consideration. Consideration is something of value. Clarify whether or not you or your agency is asking for gold or silver coin as payment of the alleged debt or private commercial paper. Who was listed as the mortgager? What was the original debt owed before the securing of the mortgage, i.e. the pledging of the estate as collateral or surety? What exactly is being borrowed from you or your agency? If whoop-de-whoop is listed as the mortgager, i.e. the holder of the title to the property, what exactly is being borrowed from you or your agency? Does the word foreclosure mean before the closure? Like we talked about last Friday. Remember, it's always a closing, right? When you sign docs. So it should never be a foreclosure because the closing already happened, right? For means before the closure. That just doesn't make sense. Is a closure the signing of an instrument or contract? Can a foreclosure be executed after a closure? Can corporations, official persons own property or the holder of any real instruments? And back because there's always going to be somebody, a bank saying they own property. Banks can't own property. Human beings own property. And that's why it's back to the nationality, jurisprudence, knowing law based on where you at, because once you start being like, okay, who's the CEO of Chase? Who's the CEO of these banks that's saying they own the property? Now it's what's your nationality now? How is your claim higher than ours? That's what it's going to come down to. Most of these banks, by the way, are their subsidiaries, their headquarters are in like Europe. Chase Bank, Wells Fargo, Chase, Citibank, all these is when you look at their headquarters, England, London, you know what I'm saying, Belgium. It is not true. Is it? These are questions. Is it not true in congressional bill, House Resolution 5404, that the United States Congress admitted the USD has lost 96% of its value? Therefore, any alleged claim of lending is only worth 4%. Right, to my Federal Reserve notes, USD will be United States dollars, which will be Federal Reserve notes. Subsequently challenging the equitable securitization of the home in question, as the value of the home far exceeds the value of any physical payment of USD, right? USD ain't worth nothing. It's already been decided by they people. Congressional bill, House Resolution 5404. Is it not true that the United States Supreme Court stated in Don E. Williams versus the IRS Commissioner case that Federal Reserve notes are considered a conditional payment, meaning both parties must agree to the value thereof, and I cannot be forced to pay you in notes, right? Because a note is a promissory, right? Promissory note, Federal Reserve note. Is it not true that in order for a contract to be valid, there must be fair or sufficient consideration? And I kind of just lightweight talked about that. Look up consideration. Actually look up the 10 maxims of law, and you'll see that's one of the maxims. Look up contract law, right? Contract law, highly recommended to dive into. In Article 1, Section 8 of the Constitution, protects all contracts if they're valid. And we know for a contract to be valid, there's a couple of things that need to be in place, right? It can't be a linear, can't just be one signature. If it's 4 parties involved, right? Can't contract with a minor. These are just, it must be consideration. This is contract law um, basics, you know. Is it not true that the Fair Debt Collection Practices Act, FDCPA, is a federal law founded at 15 USC section 1692 that regulates the behavior of collection agents? And you must therefore answer this discovery, lest ye be found liable in punishment to all subsequent USC United States codes in violation of the FDCPA and can be charged for estate embezzlement under Title 18 USC 153. That's a question. These are questions. This is my good faith to attempt to clear up any misrepresentations or confusion concerning this matter before taking any further actions. A failure of the aforementioned entity or representatives to respond within the allotted 10 days of receipt of this writ in the nature of discovery will be deemed as dishonor of this notice and demand for disclosure. Without animosity, without malice, issued by my hand with a sound mind on this day, et cetera, I am, et cetera. And then, of course, all affidavits come with witnesses. It's always somebody witness the truth that you're putting on paper. Supportive case law. And I wanted to talk about something earlier when I mentioned as far as the allonges and the things that anything related to the instrument, to the mortgage instrument. Once again, people invest in mortgage notes. Any common man or woman can invest in mortgage notes, which means you can it could be at 6%, 10%, whatever the percentage is. You basically said, I'm going to invest this and I'm going to yield 6% in 90 days or whatever the stipulations is. But once again, on the flip side, there's somebody actually paying the mortgage at 6%, 10% fixed or adjustable. So that in itself lets you know that it's a negotiable instrument, the promissory note. And if people are making money off that, and you are the holder of the promissory note, you're supposed to get paid because that's your note, right? If it wasn't for you completing the contract, it would be no people in the background making money off of it. So they needed you. And it's also a violation of, once again, SEC laws, Security Exchange Commission laws, right? Which is another conversation. All right, so supportive case law, money. In usual and ordinary exception, it means gold, silver, or paper money used as circulating medium of exchange and does not embrace notes, bonds, evidences of debt, or other personal or real estate. Coming from a case law, or a case law to reinforce Lane versus Riley, it was brung up this fact, right? That notes are not money. It's a promise to pay, but not paid. Note, a unilateral instrument. Remember I said no unilateral contracts? So a promissory note is and once again, unilateral just means one-sided, uni. A unilateral instrument containing an express and absolute promise of signer to pay to a specific person or order or bearer a definite sum of money at a specific time. Case law. An abstract, a memorandum, and informal statement in writing, right? Case law to support. Treasury note. What's a treasury note? A note or bill issued by the Treasury Department by the authority of the United States government and circulating as money. See Brown versus State. What's a promissory note? A promise or engagement in writing to pay a specific sum at a time, therein limited, or on demand, or at sight, to a person therein named, or to his order or bearer. Case law to support that. A written promise made by one or more to pay another or order or bearer at a specific time, a specific amount of money, or other articles of value. Case law to support that. An unconditional written promise signed by the maker. The maker. That's the key. That's the key part. That's what I was getting at. The maker. You're the maker. Whoever saying they got the mortgage or they're saying they gave you a mortgage, that means that's your trust. That's your instrument, and you're the maker of it. So once again, if there's money being made off of it, you need to get that and be aware of that's the case. The maker to pay absolutely at all events a sum certain in money, either to the bearer or to a person therein designated or his order. Case law to support. At a time specific therein or at a time which must certainly arrive. Case law to support that. Contract. What is a contract? A promissory agreement. Now we're talking about an agreement. Distinguished from a note, we're talking about an agreement now. A promissory agreement between two or more persons that create, modifies, or destroys a legal relationship or a legal relation. Case law to support that. A contract is also an agreement, of course, upon sufficient consideration. Back to consideration. Once again, look that up. Something of value. To do or not to do a particular thing. Case law to support. A deliberate engagement between competent parties. Competent parties. That's why minors cannot be a party to a contract. Competent parties. Upon legal consideration. Something of value. These are elements of case law, contract law in the definition of contract. Multiple elements in here. A deliberate engagement between competent parties upon legal consideration to do or abstain from doing some act. Now let's get into the definition of consideration, right? Even though I've been talking about that, but here it is, a visual. Consideration is not to be confounded with motive. Consideration means something which is of value in the eye of the law. Article 1, Section 10, what's money? Gold and silver, according to the law, right? See where we're going with this? Moving from the plaintiff, either of benefit to the plaintiff or of detriment to the defendant, case law to support. Nothing is consideration that is not regarded as such by both parties, right? So if we're not going to use money, talking about Federal Reserve notes or whatever the case may be, it must be agreed on by both parties, the value of that non-money. And price and consideration, though sometimes the same, are not always identical, right? Because one's lawful, one's just, like I say, both parties got to kind of agree to that. If not, they're trying to get over. An act which, if done, or a promise which is enforced, would be prejudicial to the public interest. They're telling you illegal consideration, an act which, if done, right? So illegal consideration would be something that's not consideration. Was not consideration. Non-money, right? An act which, if done, or a promise which, if enforced, would be prejudicial to the public interest. Legal consideration. Legal consideration. one recognized or permitted by law as valid and lawful, as distinguished from such as are illegal or immoral. The term is also sometimes used as equivalent to good or sufficient consideration. See Sampson versus Swift. All right. So pay, law definition of pay. To discharge a debt, to deliver to a creditor the value of a debt, either in money or in goods for his acceptance. Case law to support that. And I'm actually going to stop right there. And we could pick this up next time. Any questions, comments, analysis? Learn something new?
Islam. It's just divine timing. This is some of the similar stuff that we've been studying. And this is probably the next level of enacting our ancestral state. And Allodial, basically. So we would have to be doing these writs too for some of the discharging, basically.
Mm-hmm.
Right? Monthly. Yep. So yeah, this is an alignment. We're looking to get all the best pieces. You gave me a couple extra pieces I didn't know tonight too. So yeah, Islam.
Islam. Anybody else had any questions, thoughts? All right. I'm going to do one more round for questions and thoughts or for anything. If not, I'm going to go ahead and close out. It's been a long day today. Somebody has something? Anuna?
Oh no, I was just I was just saying Islam to everybody. That was great information, as usual, as always. So I want to study I gotta study that law a little bit.
Yeah.
That's all before I have any questions, but yeah, that's fine.
Wow. You got something, Rosleon?
Oh no, just saying. I'm glad to be back. I missed Wednesday. Like I tell you, I was traveling deep, but we on the same alignment. Even if I missed that one, I'm probably gonna start. I'm thinking about maybe doing it here where I'm at my domicile right now, just to test it out. Some of that, but I got to finish my judicial proclamation and a couple other things first.
Yeah, man. Well, Charissa, did you have anything?
Not just yet. I'm definitely gonna look up like allodium because I never heard of that word before. And adverse possession, I heard of that. But the way you were putting it, it was a little kind of different, like from what I learned in life insurance class. So I guess when I get the book, I'm gonna kind of, I guess, have more questions to ask right now.
Okay.
Yeah.
Islam. Oh, Amu. Islam, how you doing? Brother Amu. I'm this Bay. How you feeling, man?
Islam, Amu.
Islam. You caught us right on the tail end, man. But Islam, man, good to see you, man. We gotta tap in, man. Chop it up. Maybe tomorrow or something. Chop it up, man. I ain't heard from you in a minute, man. But yeah, peace and love to everybody. Okay, for sure, Islam, man. See you Sunday. I'm gonna still hit you tomorrow or the next day whenever you're free, and just tap in, man. I'll be kind of busy. I've been trying to make it a good effort just tap in with the nobles, man. But yeah, peace and love. Hope everybody have a beautiful night, and I'll see everybody on the holy day and Sunday. Islam.
Peace and love, family. Islam.
Islam.
Islam, everyone.